Hi everybody, Matt Quinlan here. Welcome to another edition of Whiteboard Wednesday, where we tackle the real life issues that our clients face and we answer questions that we get from people that call our office. This week we're going to be talking about subrogation claims, and most people have never heard of that. And I often get questions from my clients when they are startled by the fact that their health insurance company is seeking reimbursement for the care that they got once they hire a lawyer or once they bring an injury claim. So I get a lot of questions about subrogation. A lot of confusion surrounds that particular topic. And so I wanted to create a Whiteboard Wednesday video about this issue so that people understand the rights that their health insurance company has to be reimbursed if you were to receive a settlement or a verdict in a personal injury case. So let's get started. What is subrogation? Well, it's a part of your health insurance contract, okay? It's in everyone's contract. People don't know it. Obviously, you know, your health insurance contract is rather long and probably not something you spent too much time reading the fine print on, but in there it does state that if you are to recover money from a third party in a personal injury claim and the health insurance company has paid for your care, they're entitled to be reimbursed. So it's a funny issue because most people feel like, well, hey, I'm paying my premiums, I have health insurance, I shouldn't be responsible for the bills, and I shouldn't have to pay them anything. That's what my premiums are for. But the particular clause in the contract that covers subrogation keeps you from double dipping. It keeps you from recovering twice. Once by having your health insurance company pay for your medical care, and then trying to recover again by actually receiving from the insurance company in the personal injury claim the value of your medical bill. So it's a common thing. We deal with it on every single one of our cases, just about, and so it shouldn't be anything that's going to surprise you. What is important to note that it only involves third-party recoveries. So if you were to receive money from somebody else, and so importantly, that does not cover UIM claims, okay? UIM is first-party claims. That's your own insurance that steps in the event that the policy limits of the third party are inadequate. And most subrogation clauses in insurance contracts do not include UIM claims, so that's good. The logistics of how it works, okay? So a lot of it requires you to self-report. You know, insurance companies aren't in the business of trying to figure out why you went to the hospital. They just get the bill from the hospital, the doctor's office, etc., and they just pay it based on the terms that they have and the agreement they have with the provider. They are not in the business of snooping around trying to figure out what exactly was wrong, what your diagnosis was, why it was that you were there in the first place, what happened. They don't do that, okay? But they're aware that they have this subrogation right in their contract. So what they do is they send a letter to people that get care, specifically and especially at emergency rooms. If you go to the emergency room, you should expect a few weeks later to receive a letter from your health insurance company asking you questions about why it was that you went to the emergency room. And they are poking around trying to figure out if they're going to have a subrogation claim. Now, I recommend to my clients that they don't respond to that first letter. The health insurance company has absolutely no idea why you went to the emergency room, if it was related to an accident, if you're going to be bringing an injury claim. No clue whatsoever. It's a complete boilerplate, cookie-cutter letter that they send to everybody, and they hope and count on you self-reporting the issue so that they can then kind of dig their hooks in, they can focus on you, they can open a file, and then chase down money that you might recover. So my advice to my clients practically is, hey, look, I mean, they send that letter to everybody. If it was me, I probably wouldn't do anything about it, and I would make them write me a second letter so that at least I felt like they have flagged my file, or at least I felt like, you know, they were aware of me and they were kind of keeping track and following up and following through and were organized. So my advice is when you get this first letter from your insurance company, don't respond to it, okay? Look, technically, you have a contract with your health insurance to cooperate with them, to give them information. So the area that I'm discussing now is a bit of a gray area, and it's really more of a practical issue as opposed to a legal one. I know that they're sending this letter to everybody, and I know that you would rather keep your money if you're able to get a settlement. As we're going to get to here, actually I'll just jump to it now, I have absolutely no obligation whatsoever to report the issue to your private health insurance company. I don't want to do that. I want you to keep as much money as possible. All the money that we have to pay back to your insurance company comes out of your pocket. So, you know, as long as it's not a governmental entity, I, as the lawyer, have no obligation whatsoever. So private is good. Government, bad, because if I have a situation where Medi-Cal is involved or some sort of governmental agency that paid for your health care, I do have a duty to report. So there's no kind of dodging it. There's no running from it. It's going to be something that if you don't do it, I'm going to do it. But with the private health care, which is most people's situation that come into my office, I don't have an obligation to do it, so I'm not going to do that. I'm trying to get you as much money as I can, and so it's really up to you. So it's a level of, you have to have your own level of comfortability with kind of withholding information, okay? You're not lying to your health insurance. You just didn't respond to their letter. So that's always my advice to my clients, and typically people take it, and it serves them well. Back to the logistics of it. So they send you these letters. Maybe they send you one or two. Don't respond to the first one. The second one is questionable. If it looks cookie cutter, I would recommend that you don't respond to that one either. Make them focus on you. Make them realize that you actually are a potential source of recovery for them and not just another follow-up letter that a machine or a computer spit out. They do hire outside companies to try to track this stuff down, and the minute that they kind of get the hint or get the idea or become informed that you do in fact have a third-party claim that's coming, they're going to probably hire an outside company that's in the business of keeping in touch with you, keeping in touch with your lawyer, following the case online if possible, if it's been filed, because they do in fact want to be reimbursed. Like I said, they're entitled to it. My goal, generally, is to try to keep your health insurance company out of your pocket. And I give my clients advice to try to help them do that. But when they do find out, whether it be because eventually it came to the point where just you had to fess up that, yep, sure enough, I hired a lawyer and I'm bringing a claim, or they figure it out some other way because you filed a lawsuit, for example, or a situation where a governmental entity is paying for your health insurance, then we have to honor it, okay? And so one of the services that I provide to my clients is after we receive a settlement or a judgment, I negotiate with your health insurance company a settlement for their lien on your case, okay? So they have a financial interest in your settlement or your verdict. And so I will then, after the settlement or verdict, negotiate with them on your behalf, because every dollar I can get them to forego is another dollar in your pocket. So that's a service that I provide to my clients, and which takes us into negotiating the subrogation claims. You know, the first thing I always do is try to figure out what kind of insurance policy we are dealing with. Is it a private insurance policy or is it a governmental insurance policy like Medicare, Medi-Cal? If it's a private insurance company, I'm very happy. I have a good opportunity to save you some money. Long history of successfully negotiating these bills way down. And so that would be the most positive situation. There is a type of private insurance called ERISA policies, which involve your retirement funds. Those are particularly difficult to deal with. Trying to get a reduction on an ERISA claim is very, very hard because you're dealing with people's money and they're all pooled funds that have to do with people's retirement. So trying to get a good reduction here is almost impossible. We do have some tricks, and we have been successful getting them to do it, but if you can do better than 10% when you're dealing with an ERISA claim, you're doing great. Okay, 10% is also pretty good. Sometimes ERISA claims will say no reduction, no exceptions, you know, tough. Medicare, Medi-Cal, well, I should say about the private health insurance. So in this particular instance, I will be dealing with a human being, a person that's been assigned to your file, and I will be able to communicate with him or her about your claim and their subrogation claim. And we can use kind of our personal relationship, kind of, it's a little bit more freewheeling. There's a little bit more flexibility for me and for them to negotiate the deal. It can feel right. It can feel fair. And so so there's been a lot of success at my office dealing with these private medical insurance companies. I mean, sometimes you can get them to drastically reduce their subrogation claim. I mean, for peanuts, if you don't recover a lot of money for your case and they paid out a lot, those situations are bad deals though, because you don't end up getting what you were entitled to. But, you know, generally speaking, if you can get, you know, a 33 to 40% reduction of the medical lien private, you're doing well. I'm going to get into the tricks of how I go about doing that here in just a second. And then the other type of insurance are the governmental insurance. Okay, so there's private. There's an ERISA exception because if you get one of those, it's tough. But the other is the Medi-Cal, Medicare, and other governmental insurance policies. And in those instances, it's more of a system you're working with. Did I lose you? No, false alarm. We record these live. I thought I lost you. So Medicare, so you go through a system, right? So a lot of it's done online, and I don't have the ability to interact with a particular person, which makes it kind of tough. And it's a government, so there's a lot of red tape. There's a lot of rules and regulations there are no exceptions to. So I would say that, you know, I've been successful over my career dealing with Medicare liens. They will be reasonable with you, but it's far from ideal. So, you know, in this situation, I would say if you're able to do, you know, a 33 to 40% reduction there, you're doing great, but you're probably going to end up doing a little worse than that. And then set-asides, so all the same as they're entitled to be reimbursed for the care they have paid for in the past. Well, you got some money from a third party, so that should also be covering the care you're going to get in the future, okay? So that's called a set-aside. And so in this particular instance, you have to take the government's interest in mind and say, well, listen, my client is going to need a surgery in the future or more physical therapy or something like that. And you have to set aside some money from the settlement. You stick it in a private fund and you set it there for the purpose of paying for your medical bills. So this is a complicated area of law. We deal with stuff like this here, but it's not something that we love doing, and it's tricky, and there's a lot of kind of finesse in it, and you also have to set aside some of your settlement, which is never pleasant for my clients. So let's get to the negotiation tactics about how I go on about trying to get these bills reduced for you so I can put more money in your pocket. Cost of procurement. Well, look, a cost of procurement is the cost that you incurred to obtain any money, right? So at least in theory, had you not hired me to represent you, you weren't going to get anything. You were going to be totally unsuccessful. You weren't going to get anything. And when you get nothing, then there's no subrogation claim, right? So you only have to pay back your insurance company if you actually get a settlement. And so you had to hire me on a contingency fee. I work on a 1/3, 40% contingency fee. You had to pay me either 1/3 or 40% of the settlement to get anything. So my argument is that your insurance company and their subrogation claim should also be reduced by the same amount that your total settlement was reduced by my contingency fee. That's called the cost of procurement, and this works really well with private insurance, not ERISA, mind you. I'm going to do this so you know. This is a no-go. And then sometimes you can get it to work with Medicare also. It just depends on what you're dealing with and what the situation of the particular case is. Tied closely to the cost of procurement, which again is going to be something like 1/3, 40% reduction, which is consistent with the contingency fee, is a pro rata share of costs. So all the same, I've advanced all the costs to get you this settlement. You have to pay me back those costs. And so if you had to pay for costs in the case, well, then they should have to pay for costs in the case. So the idea is they pay their fair share of the costs that were incurred as well, and they reduce their lien further. So this is very closely tied to the cost of procurement. They're oftentimes handled as one and the same, and it just involves them taking a reduction for the cost, just like you had to. And then lastly, there's a California insurance code that is used quite frequently that in short says a subrogation lien holder can only take 1/3 of the total settlement if you have an attorney. The idea being the lawyer gets a third, you get a third, and they're reimbursed a third, assuming the 1/3 is less than what they totally paid out. If it was, if 1/3 of the settlement is a bigger number than what they paid, then obviously they're going to get the small and they're not going to get the third. And then also, if you don't have a lawyer, they can get half. The idea there is, well, the subrogation company and the health insurance company gets half the settlement, you get half the settlement, and you go your separate ways. So California Insurance Code 3040 at least protects you and makes sure that you end up with something in your pocket, and it's not the type of deal where only your lawyer gets paid, or only the health insurance company gets paid, or only the lawyer and the health insurance company gets paid, and you end up with some money too, which is fair. So there you have it. That is a really brief, short, quick version of subrogation. It's a rather extended and lengthy subject. I'm happy to speak with you about subrogation claims and negotiating them, or answer any other questions you might have about personal injury matters. I appreciate you watching, and tune in again next week for Whiteboard Wednesday.